So in the interest of time, I will get straight to the story that lies at the heart of the paper that I am presenting today. And the story is about this woman called Badal Aurat, who had been married at the age of 5 to a man called Joy Lal, who was a much older man, as is often the case with these stories with child marriages. She appeared before the High Court in Calcutta in 1891, appealing a conviction for bigamy. It turned out that Badal Aurat had attained puberty while her husband had been in jail for an unrelated charge. And Joy Lal had accused Badal Aurat, his former child wife, as well as the second husband, of bigamy in one case and having unlawfully enticed his wife in the case of the second husband. Now, both Badal and this second husband had been given brief sentences of rigorous imprisonment by a lower court, and Badal had been appealing this conviction. At the Calcutta High Court, she was fortunate to finally meet with a sympathetic judge who said that Badal's first marriage had in fact been repudiated by Badal when she reached the age of puberty, and therefore it was the so-called second marriage that was valid and not the previous one. So Badal could return to her second husband and hopefully lived happily ever after, but we're not sure. Badal Aurat's case leaps out to historians of child marriage for several reasons, the first of which is that when we think about child wives in the late 19th and early 20th centuries, we are faced with what are often very tragic stories. And these are some of the most prominent cases that historians of child marriage in particular have written about from this period that I'm speaking of today. So one of the most prominent cases that we hear of is the case of Pulmoni Dasi from 1891, who was an 11-year-old wife who was basically raped to death by her husband, and that it led to the agitation to raise the age of consent in 1891. The Age of Consent Act was passed in 1891, which ended up extending the age of consent to 12 years of age and also extending that protection to wives. Another case that we encounter and historians have written about is the case of Rukma Bai from Bombay from 1885. And that was a case for the restitution of conjugal rights. Rukma Bai famously did not want to return to her husband, to whom she had been married at the age of 11, but she was ultimately returned to him so that he may complete his contract with her by consummating the marriage. There is also an earlier case that historians have written about, which is of Huchi or Helen Gertrude, and this is from Madras in 1873, who had converted to Christianity and tried to leave behind a marriage that had been contracted for her by her parents while she had been a child. In trying to leave this marriage, this young woman had simultaneously challenged the authority of her husband, her family, and her community, which insisted that Hindu marriages, once contracted, could not be dissolved. She was defeated. The council suggested that if her marriage were to be voided, it will follow that the religious opinions of children are taken so seriously that they have the legal effect of taking away that the right that Hindus value above all, and I'm quoting the judgment, the right of disposing their daughters in marriage. Badal's case, as we shall see, was not only a strong counterpoint to the more common cases that we write about as historians of child marriage, but also addresses a gap in our acknowledgement of alternative legal traditions in the handling of so-called child wives from the late 19th and early 20th centuries. And I'm using the term so-called child wives quite deliberately For this talk is based on a provocation. The child wife that we write about as historians today did not exist as a stable legal category until the period between 1891, right? And the child wife was brought into being by legal reform and reformist politics, most importantly between these two laws, which will be the time span that I'll be covering in the talk today, the Age of Consent Act of 1891, which tried to tackle the problem of child marriage indirectly by extending the age of protection to wives as well, and the Child Marriage Restraint Act of 1929, which fixed the minimum age of marriage at 14 for girls and 18 for boys, and also defined the child in the context of the law as a male who is under 18 and a female is 14 years of age. And you will see that the definition itself is quite gendered, that a child is assumed to be below a certain age, and it varies by gender. And that's something we can talk about a little bit more. But the Child Marriage Restraint Act also famously did not invalidate child marriages once they had been actually contracted. So by the 1920s, which is the decade in which the Child Marriage Restraint Act had been discussed and finally was passed into law, a new typology of the child wife was being propagated in India as well as in Britain as well as abroad by a series of reformist publications, some of which have been extensively written about. And this is just to give you a sense of, these are just three examples of the proliferation of writing on child marriage that was happening in the decade of the 1920s and 30s. So the three works that I'd like you to consider and keep in mind as I speak is one by Catherine Mayo called Mother India, which was published in 1927. Another published by the British activist Eleanor Rathbone, published in 1934, Child Marriage, the Indian Minotaur. And the third one, Shubala, A Child Mother, written by Cornelia Sarabji, who is famously India's first woman lawyer, and this was published in 1920, so the earliest one. So each of these books played with the imagery of childhood in danger, and the girl child in India as particularly vulnerable. And in the most provocative and controversial of these texts that Mrinali Sinha, historian of South Asia, has written extensively about, Mother India, Mayo had proclaimed that it was because of the biological deterioration of Hindus caused by practices such as child marriage that explained the greatest demographic mystery of colonial history, that of 67,000 holding down 247 million. And this explained why the Indians' hands are too weak, too fluttering to seize or to hold the reins of government. So it is no surprise in some ways that nationalist political effort was quite focused on the problem of child marriage throughout the decades that the nationalist movement was picking up steam, which is the 20s and the 30s. And there were literally dozens of laws that tried to address the problem of child marriage that were passed in the princely states as well as by various provincial and the central Indian legislature. And these are just some of the examples. So Harbilash Sardas, who was the author of the Child Marriage Restraint Act that was passed in 1929, had initially written the Hindu Child Marriage Bill of 27, and you can see that the definition of girl and boy was slightly different at that time, and he had in fact previously proposed that marriages contracted below that age should be invalidated. And these are just two examples, or three examples rather, of some of the laws that were in place in the princely states of India. So the Khilchipur law, 16 and 12 were the minimum ages for boys and girls. The Tehri States Child Marriage Act from 1936. and the Quota State Marriage Act, which was slightly more complex and suggested that marriages between previously unmarried girls to males above 45 should be invalidated, and so on. What all of these various bills and acts had in common was one thing, and that was the belief that the specification of a minimum age would somehow resolve the problem, which comes from the broader belief that age was a quantifiable measure of legal subjectivity, and it could be handily established and measured. But this logic established by the Child Marriage Law of 1929 has served as a template for all subsequent laws that have been passed in post-colonial India, for instance. The age of marriage had been raised to 15 in 1955, and then to 18 in 1978, where it now stands. So what we will try to do today is take this curious step and question whether there's a way of thinking about legal subjectivity without thinking about age as the most stable measure for it. But to return to the case of Badal Aurat. Badal Aurat was perhaps lucky that her appeal was heard by Justice Amir Ali, a man who prided himself on having used every chance he got as a magistrate and as a judge to ensure that offenses against women and children were given the severest punishment he could possibly inflict. A jurist armed with extensive research on Islam and law, Amir Ali was a self-proclaimed member of the philosophical and legal school of the Mu'tazilas that had originated from the desire to return or revert to the pristine purity of Islam. With an eye to effecting this change, Ali used the opportunities that were provided by colonial courts to reinterpret the Sharia in ways that showcased Islam's ability to modulate its tenets with changing times. He had an exceptional legal career as the first Muslim to serve in a high court in Calcutta, and also the first Muslim to serve in the Judicial Committee of the Privy Council. And his judgment in the case of Badal Aurat, with which I began this talk, demonstrates not only his fidelity to a conception of Islam as progressive with regard to gender relations, but also exemplifies a mode of reasoning that was intended to make practice reflect his exalted vision over time. In considering Badal Aurat's case, Amir Ali had asked if there was sufficient evidence to establish the fact of Badal's bigamy. The matter was settled easily enough. There was no evidence that he could find that a mullah had presided over the so-called marriage ceremony. There was no evidence that a sigha or a formula that was appropriate to minors had been read at this ceremony. And he concluded that while it was quite likely that Badal had perhaps been promised to Joy Lal in marriage, the marriage had in fact never taken place. But so this alone would have been enough to dismiss the charges of bigamy against the child wife. But what Amir Ali did with the case was to try and clarify what the status of such child marriages were in Islamic law as such. The question of infant marriages would not have been far from his mind, because Badal Aurat's case was heard in 1891, which is the same year that the Age of Consent Act had been passed. So according to Amir Ali, the status of child marriages in the Sharia depended on a range of relational criteria. Who had contracted the marriage for the minor? Was the match made for the child a suitable one on religious and ethical grounds? And the answers to these questions depended also on the sectarian affiliation of the family and the child in question. Under Muslim law, he clarified, a girl given in marriage as a child had a right to the khayarul bulugh, or option of puberty under certain circumstances, That is, she could repudiate the marriage upon attaining puberty. While marriages contracted by a father or a grandfather were generally binding, he also established, along with other scholars of work on Anglo-Muhammadan law, of course, that there was an entire series of relations depending on which determined how binding a marriage was or not. And although Badal's sectarian affiliation was not clear, Amir Ali suggested that she could claim the option of puberty to dissolve her marriage, whether she was a Sunni or a Shia. Among Shias, such a marriage had no status unless ratified by the minor on reaching puberty. Amongst Hanafi Sunnis, a minor could cancel the marriage when she came of age. Since Badal's husband had been in jail when she had attained puberty, it had not been necessary for her to say yes or no to that marriage. And by marrying another man, that action alone was enough, according to Amir Ali, to signal that she had not, in fact, consented to her child marriage. In his textbook on Anglo-Muhammadan law, which was extensively used in the 1920s by other judges and lawyers, Amir Ali used the case as an example of the ethical superiority of Islam in the treatment of women, its procedural capacity to interpret tenets in keeping with changing times, and its fundamental compatibility with what he called natural law in terms of the core values that guided the delivery of justice. The confirmation of Badal's option to leave her marriage was highly significant in a legal context where it was difficult, if not impossible, for women to leave marriages. Hindu women would not have that right until the Hindu Code Bills of 1955. And even the Child Marriage Restraint Act, as I just suggested, had refrained from making child marriages invalid. And Badal's case and this particular judgment passed by Amir Ali therefore served as a precedent that was repeatedly cited through the 20s and 30s in order to let Muslim child wives who appeal these cases to leave their marriages behind. In a case heard by Justice Suleiman in the Allahabad High Court in 1925, Aziz Bano had appealed a case for the restitution of conjugal rights mounted by her husband with a fourfold defense. She said that she had not been aware of the marriage that had been contracted for her while she had been a minor. Her father had not consented to the marriage either. She was a Shia and the plaintiff was a Sunni, and the marriage was thus invalid. Finally, she claimed that she had also repudiated the marriage using the option of puberty granted to her. The trial court, as well as the lower court of appeals, ruled that contrary to her claims, the father had consented to the marriage. Since marriages contracted under paternal authority were particularly binding, she did not, in fact, have the option of puberty. And since marriages contracted between Shias and Sunnis were, in fact, perfectly valid, there was no way that she could challenge the validity of the marriage on that ground either. But the bench at the High Court in Allahabad chose to follow in the reformist tradition and use the case of Badal Aurat as a precedent to evaluate each of these points to finally reverse the decision, essentially freeing Aziz Bano from her marriage. Citing a long line of texts, the judge conceded that the marriage was seemingly binding as it had been contracted by a father. At the same time, he passed the question of validity in marriages by correcting translations in various texts to distinguish between what he considered prohibitions in marriage, haram or hurmat, and conditions in which a marriage would be considered obnoxious or offensive, makruh. Justice Suleiman considered that while there was absolute unanimity that a marriage between a Shia and a Sunni would be valid, there was also a suggestion that such a marriage would in fact be considered offensive or obnoxious. Using the language of child rights, he further argued that the Sharia was particularly attentive to the rights and interests of children. It takes care that the jabr or parental authority that the guardian has should never be exercised to the prejudice of the infant, and any act of the father which is likely to injure the interests of the minor is considered illegal. And such an act entitles the qazi or the judge to interfere in order to prevent the completion of such an act or to intervene to annul such an act. Now, pronouncing the Shia's marriage to a Sunni as offensive on some grounds, and certainly offensive to the daughter who had been married, which in turn put into question the father's judgment in having contracted that particular marriage, he ruled that the marriage in fact had been offensive to the girl and that therefore she had regained the right to repudiate that particular marriage using her option of puberty, which had become available to her. Now, continuing with this tradition of generous interpretations, Justice Faiz Badruddin Tayyibji of the Bombay High Court upheld, in a similar case, upheld the right of a girl called Amina Bai to remarry and to leave a marriage that had been contracted at the age of 9 to a man called Abdul Karim. Abdul Karim had filed a case for the restitution of conjugal rights and to prevent a second marriage. Now, while admitting that the girl had been a minor at the time of the marriage, the husband insisted that the girl herself had consented at that time, and therefore she had lost her option of puberty. And moreover, the girl had been in the presence of the husband when she attained puberty, which would mean that she had consented through her silence. The judge disagreed, stating that the option of puberty is given to the wife and is based on principles repeatedly emphasized in the Quran. It is one of the safeguards by which Islam alleviates the incidence of pre-Islamic institutions pressing harshly against women and children, that it has to be constantly interpreted in a way that therefore ends up aiding a woman in crisis rather than the other way around, and said, and therefore in his judgment confirmed that the girl had the option of puberty, that she had exercised it, and she could repudiate the marriage several years after she had in fact attained puberty and had remained with the husband. So in these three cases that I've talked about, the option of puberty was interpreted with increasing degrees of flexibility. And judges favored the desire of the child wife, so to speak, in order to let them exit these marriages that they considered obnoxious to themselves for various reasons. The understanding of consent, the consent of the wife in these three cases, hinged neither on the biological fact of puberty nor on a documentation of chronological age. And the reason why I consider this important will become clearer when we talk about, as I go on to talk about the Child Marriage Restraint Act and how that, in fact, was implemented in courtrooms during this time. So during the time that I've surveyed here, roughly between 1891 and 1939, reformist attempts to restrict child marriages had grown more and more strident. While cases such as Badal's were appealed in various colonial high courts, the Child Marriage Restraint Act that invalidated child marriages for everyone, irrespective of religious community, had also been passed in the meantime in 1929. Yet, until August 31st, 1932, which is just over 2 years after that child marriage law was passed, there were just 473 prosecutions, of which 167 had in fact been successful, but all but 17 were punished only by a minor fine. So these child marriages that had been contracted, in fact, remained wholly binding for the persons concerned. Pondering the causes of the failure of the Child Marriage Restraint Act, which failed to even restrict or to prove as a disincentive in some ways, which had been the hope, because people just seem to have contracted child marriages at a higher rate after the passage of the act rather than before, for instance. So in trying to figure out what explains the causes of the failure of the act, legal commentators at that time as well as now have suggested that courts were unlikely to rule against the accused in cases tried under the Child Marriage Restraint Act unless it could be established beyond doubt that the child in question is below the minimum age. And it turned out that this was easier said than done. Census officials in India, both in 1911 and 1921, when the previous two censuses before the Child Marriage Restraint Act was passed were carried out, had repeatedly insisted that age, which seems to work in a Western context, did not in fact translate into useful data when it was imported into contexts such as India. In their report, census officers recounted the widespread variation in how people accounted for age. Some counted from the period of gestation. Others considered that a child was already a year old when the child was born. They mentioned Indians' propensity to round up or down, the use of natural events to recollect age, which often led to mistakes and errors, the exaggeration of the age of adolescent girls in particular, a taboo on revealing a child's name until it reached a certain age, which led to a problem where sometimes there were registers of birth, but people didn't know which child had in fact, whose birth had been registered was not clear at a later date. A common word was used in many Indian languages for nearest and next, and because most Indians made no distinction between the age at the last birthday and the next one, any return of age could be off by a year or even two, and this is what the census officials were suggesting. And despite this problem, what we have is the use of the census on the one hand here in the chart here to count up the number of child marriages. So age data is actually treated as very stable when it comes to the documentation of the incidence of child marriage. So you can see that that we have very high proportions of children being married even between the ages of 0 and 1, right? But at the same time, we also have this anxiety that is being expressed by census officials that this data cannot be used at all because we actually don't have any way of knowing how accurate this is. And one of the things that the census officials talked about was also the use of particular digits of age that were favored. So what you can see from the chart here is that most people were likely to just report their age that ending with a 0, a 5, or a 2. So if I were 34, I'd just round it up and say I was 35, which led to, so the chart here basically shows that the number one preferred digit of age was 0, which means people were most likely to say that they were 10, 20, 30, etc. And the second was 5, and the third was 12. And the highest reporting that took place with the ending in 2 was parents claiming that their daughters were 12, which was the age of consent at the time. So these two sort of proved to be particularly misleading and a difficult problem. But it was not only at the level of this this kind of statistical data that the proof of age was difficult to come by. And case upon case that was tried under the Child Marriage Restraint Act, what you can find is that those who are accused of flouting the law manage to escape because they can always contest the proof of age that has been provided. So in one case from Calcutta, the judge heard an appeal from a father who had flouted a magistrate's injunction to refrain from conducting an infant daughter's marriage. The father claimed that the girl had in fact been 14 at the time of the wedding. No evidence could be found to the contrary. And you can imagine why. So the father could just walk scot-free, because the assumption being that the parents knew best what the age of the child was. In a case from Allahabad in 1933, though, a rare sentence was upheld, even upon repeated appeal, but it was not because a stable and reliable proof of age had been provided or found. What happened in that particular case from 1932 was that two men who had been accused of arranging a marriage and officiating in a marriage that involved a child insisted that they had been misled about the child's age. Their defense had produced a document provided by a woman medical officer in charge of a local hospital that confirmed that the girl was above 14. The court called in a civil surgeon who estimated the girl was about 12 years of age. Given the discrepancy in the opinions of the two experts, the judge asked if the two men had indeed consulted an appropriate expert in determining the girl's age. The judge pronounced that the woman they had consulted was no expert at all, because what she had done was, in providing the estimate of age, she had dismissed the authority of medical forensic experts such as Lyon and Powell, and she had cited these two by name, who were extensively used in courts in matters of where forensic expertise was required. So it's interesting to think about what were these exacting standards that were provided for determining age in texts such as Lyon's Medical Jurisprudence for India that the judge cited. Ironically, that these very authorities were very concerned about the unreliability of the proof of age that could be found by medical experts. They suggested that medical experts might estimate age through the examination of teeth, through height and weight, hair and breast development, degenerative changes in the body, and the extent of ossification or bone formation. Now, while some of these, such as bone formation or deterioration of the body, would prove to be quite useful when age or sex had to be determined in the case of a corpse, they seemed quite useless when it came to determining very accurately what somebody's chronological age was in the courtroom. The order of the appearance of milk teeth in infancy, and you can see here that this was taken as one of the signs. Certain teeth appear only in the 8th year, and then you start getting more teeth as you age. So that could have been the most reliable proof of age in that window between 8 and 14 that experts were most interested in cases of child marriage. But Lyon wrote, in natives of India, a few exceptions have been found to these figures, and these exceptions will be found on the precocious side, rarely at later dates. He suggested that while canines usually appear during the 11th or 12th year, Lyon had in fact seen them in India in a child as young as 9. So that too was being thrown into question. If a child in India at the age of 9 could show the teeth that you would not expect to find elsewhere at the age of 13, it throws that kind of data into question. And if the observation of teeth could mislead, the tables on the average heights and weights that were also used to determine somebody's age simply did not even aspire to correspond to reality, at least in the textbooks that was circulating until the 1920s and 30s. As late as in 1921, Lyon's textbook admitted that there was no special Indian observation on the relations of height and weight. What he provided was data from England, and he included the hint that in the majority of Indian races, the average height and weight is lower than that of Europeans, therefore encouraging whoever is interpreting the forensic evidence to keep that in mind. But forensic experts therefore made fairly modest claims about their skills in reading the truth of age in native bodies. After adult life is reached, Lyon wrote, the age is only to be guessed at approximately in the absence of a regular certificate of birth or a horoscope. So it is not a surprise that women such as Cornelia Sorabji and Eleanor Rathbone, who I mentioned earlier on, who were writing extensively about child marriage and pushing for legislation which would put this problem to an end or at least control it, insisted that birth certificates would offer a solution. Rathbone suggested a compulsory and accurate marriage register, universal compulsory notification of birth, including a child's name and sex, free birth certificates to be issued to all. Sorabji even proposed that birth registration would have to be followed up with visits to these homes to ensure that, with a follow-up registration, in other words, within a year of the birth of the child. How can offenses against the law be proved unless the age of a victim is known, as Rathbone famously asked? What I've tried to do today is provoke us to think about an alternative question. Why must the securing of rights or the provision of protection rely on such a seemingly fragile quantity such as age? If age is truly a universal mode of accounting for the self, why did it falter in a particular local context? To answer this question, we have to step outside of liberal notions of rights, justice, and of standards of proof that are upheld in courts. And I'm going to, I leave some time to talk about what that entails, but I will just conclude here in the interest of time and leave you to ponder what the sources can be for us to question the faith that we put in age as a stable ground for determining that difference between child and adult, which is clearly so important in the liberal political tradition and the liberal legal tradition, but also think about what happens if we sort of reverse the line of reasoning and do not think of other religious or cultural legal traditions as deviating from the norms that are set or as somehow failing to match up to those standards, but use the concepts that are offered by alternative systems. So with Badal's case, these alternative concepts would be Bullock and Rushd, discretion and puberty, and the evidentiary standards for ascertaining what puberty is, what discretion is, also is different in the Islamic tradition, as we've seen. So what about we approach those problems from that end? And the other sort of literature that I've drawn on to think about whether it's even possible for us to start pushing beyond age is the literature in queer theory that questions the naturalization of age stratification, which is to assume that the body can only do certain things at certain points of time as we age, and that there's a very clear chronological line between between being 12 and 13 and so on. And I don't have time to go into all of that, but I'd be happy to talk about some of the sciences and studies that take place in the late 19th, early 20th century, precisely at this moment, that over time help us to think about age and aging as a completely natural, stable development that is also absolutely tied to chronological age. So the cases here help us to think of legal pluralism, not only in terms of legal, cultural, or religious accommodation, but also in terms of alternative epistemologies. They help us query liberal categories for comprehending legal subjectivity and to question age stratification as a natural measure of human capacity. And what we can do is catch a glimpse of possible local solutions to the global child marriage problem and look beyond the impossible insistence that the evidence of age must be stable and reliable. So I'll just end it here, and I'm happy to take questions.